Good afternoon. We're curious. Do we have a class here?
Yes, Your Honor. We have Paul Helton at the University of Tennessee College of Law. We have first-year law students in their second semester, and they're doing their own appellate oral arguments a week from today.
Okay. Well, if you'd like, after we finish both cases today and adjourn court, we'll stick around for a few minutes if your students would like to ask us. They can't ask us questions about how we're going to decide the cases, but other questions, we'd be happy to talk to them.
Okay. Also, if you're arguing, do a really good job because you're setting an example for these
Yes, that's
people.
right. Y'all are setting
Don't screw it up.
You're setting the standard now, so call the first case, please.
Judge Hurst v. City of Morristown.
Sometimes you can learn from people's mistakes more than you can from their positives.
Are you setting us up for what's to come, Mr. Lauterbach?
I sure am.
I was going to ask if we could just submit our case on brief. Too late for that.
We'll hear from the appellant.
Thank you, Your Honor, and good afternoon. My name is Benjamin Lauterbach. I represent the City of Morristown in this case. Would respectfully ask for 3 minutes of rebuttal argument.
3.
Yes, Your Honor.
That'll be fine.
Thank you. This, if I may just jump quickly into the facts of this case, they're not overly complicated. This is a car accident case. Vehicle, pickup truck operated by Mr. Hurst ran into the back of a city street sweeper while it was engaged in sweeping activities. The street sweeper was going 7 miles an hour, according to testimony at the time of the accident. Mr. Hurst was traveling 40 miles per hour at the point of impact, which was the posted speed limit on this particular roadway. This was a 4-lane highway in the city of Morristown. It was devoid of traffic. The main reason for that, I've received this question, is because it was in an industrial zone and it was between shifts, which is why the city had a plan in place to sweep that particular time frame. Beautiful day, much like today. The sun was out, visibility for acres and acres. This particular roadway was an anomaly in East Tennessee. It was straight. It was fairly flat, very slight uphill grade. There was at least a quarter of a mile, arguably a half mile of complete visibility available to Mr. Hurst. As he approached the incident, so the point of impact, he made absolutely, uncontested, undisputedly, no effort to slow down his vehicle. No effort to avoid the street sweeper, go into the left-hand lane. The accident occurred in the right-hand lane. No effort to brake.
Was there any testimony regarding visibility as to whether or not he was able to see the street sweeper or whether or not there is something in his sight or something of that nature?
Yes, Your Honor. The complaint alleged there was a phantom vehicle. There was no proof of that at trial, and the trial court disregarded that assessment. The complaint was devoid of any other obstruction. The complaint was devoid of any reference to dust. Dust came up at trial as being a potential obstruction, if you will, to his view. However, and I realize this is, as an appellant coming into a situation, what I've got to show to this court on its de novo review, there's a presumption of correctness for the trial court's finding. I get that. But we can show, we believe, that the preponderance of the evidence reveals otherwise. And the reason why is Mr. Hurst, the driver of the pickup, twice said he did not see anything, including the street sweeper. Once was to his son moments after the accident. His son, Jeff Hurst, was following his father a minute or two behind. They were going to meet for lunch. He made no comment about dust, and he testified at trial that his father told him specifically, if I may read the exact quote, according to Charles Hurst, the father, telling his son while he's there in the bed of the pickup truck, "I don't know what happened. I hit something, but I never saw a thing, not one thing."
But then don't you have the driver of the work truck saying, "I think I kicked up some dust back there"?
Back down that away.
Okay.
And if you take a look at the video excerpt, which is part of the record, he's literally pointing, he's standing right beside the street sweeper when this happens. He says, "Down that away." There's no testimony how much dust that was. He just said, I kicked up some dust. Importantly, that same driver stated upon contact, he looked in his rearview mirror, or side mirror, I should say, saw the pickup truck, no dust. If you look at the pictures from the accident scene, there's no dust. One might say, where did this magical field of dust go? Presumably, gravity would have taken effect and it would have fallen on the truck. The truck has no dust on it. The glass, the windshield, the side mirror, or the side windows, there's no dust on
What
it.
about an escort vehicle or something of that nature? You got a vehicle traveling 7 miles an hour on a street zone for, 40 miles an hour?
40, yes, Your Honor.
And so that traffic is moving pretty swiftly, and all of a sudden, he's right there on this vehicle. Was there anything, any signs or flashings or even a vehicle behind that truck to let the drivers know that there's problems up ahead?
Great question, Your Honor. And the answer is yes and no. Yes, according to what was required.
That's a good lawyer answer.
Thank you.
Yeah.
Take note. The yes part of that is on the back of this truck, there were 12 specialized lights, flashing lights, different colors, including a high-intensity LED light bar. According to the MUTCD, which I know this court is familiar with, I'm not going to waste my argument time talking about it, the states adopted it, you have to have certain things under this situation. Your suggestion is one of those. That would have been a plan, a discretionary plan that could have been put in place. Or, according to the standard, not my word, the MUTCD standard language, standard, which is different than shall or may, which is what the trial court relied on, you have to have these specialized lights or a trailing vehicle or signage or something of that nature. So that's the yes part. You could have had the lights. That would have brought you into compliance. The city did have those lights, the same exact lighting pattern it had for 15, 20 years, but without an accident. The same plan. The plan was in place, it was executed, and the driver didn't diverge from it. There's no evidence of that. Discretionary function immunity was where that comes into play, Judge.
Counsel, the sweeper also had a water system to hose it down to lower the dust, correct?
It had that. It could have used that if that had been part of the plan.
And it didn't.
It did not. It was not implemented that day.
And the trial court allocated, this was a bench trial, right?
Yes, Your Honor.
The trial court allocated fault, 51% to the city and 49% to the plaintiff.
That is accurate. Yes, Your Honor.
Okay, so it's not that the trial court found no fault by the plaintiff.
Correct.
They obviously found almost enough fault from your point of view.
Almost. And I realize, again, getting back to the de novo review of law versus the facts here, that if this is a 75-25, I probably wouldn't waste much of my time arguing the facts, but that's correct. We need 1%, and that bars them. Everybody knows that. The dust factor was an element, and that played a role in the trial court's assessment of fault on the city. The lack of lighting that it found, that also played a percentage to the city. The trial court didn't tell us what percentage it was allotting for each, though it did note it was a beautifully sunny day. The lights probably didn't matter that much anyway, which it's hard to disagree with that. There was a recreation video done of this using the exact same sweeper, the exact same model of vehicle, and for 20 seconds you can see that truck, the sweeper truck I should say, in that right-hand lane. 10 seconds before impact you can see the LED light bar, and as you get closer to the other lights.
Did you recreate the dust?
We don't think there was dust there that day, so it was hard to do.
But there was proof that there was dust.
There was only testimony that at some point down that way there was dust. No testimony at the scene. In fact, the testimony at the scene was there was no dust.
And the testimony of the driver, the plaintiff, that he didn't see the sweeper.
Or anything.
Or anything.
All right, that's correct.
Yeah.
Absolutely.
Okay.
You're asking us to conclude that there was no fault as far as Morristown is concerned? Or are you asking us to make an adjustment to look at whether or not there should be an adjustment to the findings of the trial court as to fault?
We believe that if this court finds that there was, in fact, the preponderance of the evidence goes against the trial court's finding, then there should be a no fault on the city. It followed the plan. just as it had for years. There was no act of negligence, in other words. If this court is going to support the trial court's finding of negligence on the part of the city, then we get into immunities. And we get into discretionary function immunity, which Your Honor's already brought up through his question. If they applied a different plan, then that's a discretionary function. If that plan was negligent, if it was flawed in any capacity, immunity attaches. Equally, if not more important, I want to bring up the public duty doctrine. This is a doctrine that two of the panelists I'm before right now held as recently as a year and a half ago is alive and well in Tennessee. The King versus Selmer case, which your peers out of the Western District issued a ruling on, shortly before this trial, and this case was presented to the trial, the King-Selmer case was presented to the trial court, it specifically held that a plaintiff must plead special duty. If you're going to start with the concept that governmental entities are no longer going to have the immunity umbrella over them, and you start peeling that immunity away, that's great, and that is what the law is, and it has been since the mid-1900s. 1968, I believe, is when the GTLA came into effect. However, there's a misconception, it seems, between removing immunity and removing all immunity. And what this court, based on the Tennessee Supreme Court's ruling in Lawson versus Hawkins County, has held is that the public duty doctrine existed before the GTLA, it exists after the GTLA, and currently. What the King versus Selmer court said is you must plead a special duty owed. Simple truism, a duty owed to all is a duty owed to none. If you review the complaint in this case, there is no reference, I've mentioned dust, no reference to dust in it. There's also no reference to any special duty of care owed Mr. Hurst. In fact, I believe it's paragraph 13 or 14 of the complaint, actually uses the word motorists, plural. If you review the trial court's opinion, it maintains that the city was at fault because it owed a duty to motorists, plural. There is no evidence in the record that a special duty was owed to Mr. Hurst versus the public in general. In fact, the only testimony was the duty of care owed was to the public in general. The specific question asked of the plaintiff's expert, did the sweeper owe a duty to Mr. Hurst, was responded to by the plaintiff's own expert saying, in short and paraphrasing, this was a duty owed to citizens, to motorists, to pedestrians, to anyone using those roadways. The duty of care owed was general in nature. If that's the case, and if that is true, the public duty doctrine applies. There's no getting around it. The appellees in their brief cited this court to only one case. Lawson, also coincidentally, Lawson versus City of Maryville Schools, an unreported case from 2020. It held that a basic absurdity would occur if you allowed the public duty doctrine to trump, in that situation, 292203, dealing with dangerous sidewalks. Here we're dealing with 202, dealing with negligent operation of motor vehicles. But the Supreme Court in Lawson, Hawkins County, and then this court through on the remand portion of that opinion, found that it's not an absurdity, that the public duty doctrine has existed, continues to exist, and should prevent situations like this from proceeding against the appellant or the city because immunity attaches if it doesn't under discretionary function immunity.
You have your time for rebuttal.
Thank you.
Thank you. We'll hear from the appellee.
Good afternoon, may it please the court. I'm Lewis Jenkins, and along with Mr. Gabe Stapleton, I'm here this afternoon on behalf of Jeff Hurst, the plaintiff in this case. So here's what was undisputed in the facts in the trial court. On March 8, 2021, it was a clear day. It was the very first time that year that the streets had been swept in Morristown. Everybody agreed that the very first time the streets are swept, it was the time when they were the dirtiest and the dustiest. And Mr. Kimbrough failed to engage the water system, the water jet system, to hold down the dust. And then, here's what was disputed, whether or not the dust had anything to do with it. Well, the trial court resolved that in a credibility determination because it found that Mr. Kimbrough had offered two conflicting versions of whether or not the dust had had anything to do with it. And it's not hard to understand why the trial court made that determination of credibility, because regardless of whether it was down yonder a ways or whether or not it was right up on the close to the vehicle or where it was, the fact is Mr. Kimbrough said immediately after the accident that there was this dust that may have been obscuring the vision of the sweeper truck by the person behind him. And then when he was questioned at trial, and you compare the testimony that he gave at trial with his own recorded statements that are in the video that is Exhibit 29 to the record in the trial court, it's clear that he gave two conflicting versions of the dust event. And I think, as I said, by the way, on page, at the bottom of page 19 and on the top of page 20 of our brief, in that long and unwieldy sentence, which I guess would maybe bear rereading here, that Mr. Hurst hadn't seen anything in front of him. The vehicle, the street sweeper, was moving at less than 1/5 the posted speed on a 4-lane highway. It was stirring up massive amounts of dust, extremely dusty first sweep of the year, failed to use any available water jets to reduce dust, and failed to use its water trail marker to warn motorists of the dangers ahead. And then we gave about 15 cites to the record there to support that one sentence. I then went on to make a typographical error in the top of the paragraph on that first full paragraph on page 20, in the 4th line down, in that it should say the word dust, and apparently I left out the word dust, but I think from the footnote it was probably clear. In any event, that was enough. That's enough to support the decision that the trial court made. Those facts are enough without getting into any of these things about the lights, without getting into any of these things about the plan that they had, without getting into any of these things about anything else, really, any of the other disputed facts in the case, even the expert testimony. The fact is, everybody agreed this is the first time that they were sweeping the street. Everybody agreed that was an extremely dusty episode. Everybody agreed that Mr. Kimbrough didn't engage the water trail marker or the water jets to hold down the dust. And the trial court resolved Mr. Kimbrough's own confusing and contradictory statements to find that he was not credible about, in his testimony at trial, about the dust having nothing to do with it, for a very good reason. Because on common sense, which is available to the trial court just like everybody else, it didn't make any sense that this man would have run into the back of this giant street sweeper for no reason at all. And it looked like from the record there was only one good reason, and that one good reason was that his vision of the street sweeper, which had these lights on, but they were lights that, of course, we got into this, they didn't comply with the high intensity standard in the MUTCD. But take that out of it for a moment. The fact is, the very sight of it, lights or no lights, the sight of it was obscured by this dust. That's what the trial court found. That's what it based its allocation of the fault on. And honestly, I think that's probably enough, period.
What about the defendant's argument on immunity? What do you say about that, particularly the public duty argument?
So I think, Your Honor, that it is, first of all, with the public duty doctrine, I think the Lawson case, while yes, I realize that one of the arguments in the Lawson case was that the public duty doctrine did not survive the passage of the GTLA, and that one of the things that was held in that case is that the public duty doctrine did survive, number one. But number two, the fact is, this court said that you have to take into account in the application of the public duty doctrine whether or not there's an express waiver of immunity in the GTLA. And of course, under 292202, there is an express waiver for the negligent operation of motor vehicles on the streets. That's the number one contextual clue that this does not fit within the public duty doctrine. The number two thing is, the public duty doctrine is important to identify, I think, what the possible scope of victims is for an act of alleged negligence by a municipal entity. So, for example, the case, that old U.S. Supreme Court case that established the public duty doctrine, talks about the one factual circumstance that's covered by the public duty doctrine being the escape from jail. So the sheriff was negligent in letting somebody escape from jail. There's no way to identify the scope of the potential victims for that act of negligence other than everybody who's outside the jail. And that is just too large a scope. That duty is said to be owed to the public at large. But that's not the law in Tennessee with respect to motoring on the highways of this state. The law in this state is that you owe a contextual duty to protect other motorists. Yes, other motorists, plural, if you're describing it in that way. But it's an extremely semantic argument that I don't think was raised in the trial court to say that whether you identify one motorist or more than one motorist, the public duty doctrine applies, because the law is that you have to exercise due care to protect each and every other motorist, is perhaps the best way to say it, on the highways. And once you've done that, once you've articulated it in that way, it's clear that that's not the general public. That is exactly what 202 lifts immunity for, waives immunity for. And you have a situation in which the scope of the potential victims is narrow enough that it doesn't fit within the public duty doctrine. That's the way I articulated in our brief, Your Honor, and I think that's the right way to articulate the test. Because if you compare it, the classic example is the escapee. That example is obviously everybody outside the jail. Here is only people traveling on the highway at that time of the day, and that is a sufficiently narrow duty to escape the application of the public duty doctrine. So the fact of the matter is that what we have here, most of the things that were raised by the defendant in this case are extraneous to what's necessary to support the decision that was made by the trial court in this case. And as we've stated, it would be a sufficient basis for a 5149 allocation of fault in this case to say that the city's driver had created this dust obstacle that impaired the vision of anyone approaching from the back to see this, and that there was available to that person in that particular context on that particular day a way to ameliorate that dust by either the trail of water that leaves a big trail in the road that someone would see to let them know the street sweeper is ahead, and also the smaller water jets which knock down the dust that's created to begin with.
Mr. Jenkins, what about your argument regarding the medical expenses not?
Yes, sir. I've got two things to say about that. Number one is that under the statute, so the trial was held in February of 2023. The itemized list was served and filed on October the 13th, 2022. So the 90-day threshold was met, and the timing was met, so that the first element of the statute was met. And then, so we've got the reasonableness of the bills being covered by the application of the presumption statute. There was no evidence offered at trial by the city of Morristown to rebut the presumption that the bills in that itemized list, which appears at Trial Exhibit 17, they didn't offer any testimony to rebut the reasonableness of those bills.
What about the necessity of the bills?
Yes, sir. And I think that the two pieces of medical, we got two ways to try to demonstrate that. Number one, our first position is that the fact that this man ran into the back of the street sweeper, there was this crash, and he had an open femur fracture, is enough to meet the obvious.
Yeah, but wouldn't that take expert opinion? Testimony?
The way I understand the law, Your Honor, the law is that it takes expert proof unless it's so obviously connected to the necessary part is the connection between what happened and the need for this medical treatment. And as I understand the case law, it is that once you've demonstrated the reasonableness, you can demonstrate the necessity in one of two ways. Number one, by expert proof. Number two, by arguing that the need for medical treatment is so obviously necessary with this particular injury that it can be, that the bill can be found to be necessary. And with respect to that, we say that the first instance of treatment at UT Medical Center, which was being treated, making an emergency treatment for that. If somebody's got a bone sticking out of their leg, I think it meets the obvious requirement. The second part of that was
that's what the open fracture means. The bone is out.
That's the way I understood it, Your Honor, and the way, even supplementing that with the medical proof, was the doctor seemed to indicate that was also the case. I didn't see, there weren't any pictures of the injury in the trial record, and that's the way I understood that injury to be, based on, number one, the plain meaning of that word, and number two, the medical proof that was offered by the doctor's name, who I can't pronounce, but that starts with a T.
Are all of the bills that you submitted directly related to the treatment of the open fracture, or are they, he had some significant subsequent issues that, I mean, I think it's like $250,000 worth of bills. Is that for the whole 6 to 8 months of his course of action after the accident, or just the initial ER?
So we had two arguments, Your Honor. Number one, that in failing any other argument, that the UT medical, the first bill on the itemized list in 17 was the UT medical emergency expenses, and that those would be covered in any case. And then secondly,
How much of the 250 was that?
Well,
I mean, I'm sure it's in the record. If you don't know, it's fine.
so I'm going to shamefacedly admit that I anticipated this question, and I got out Exhibit 17 out of the larger notebook that contains the record, and then I only got the first 2 pages of it. So
It's okay.
We'll
We'll find it if we need it.
Mr. Louderback has just helped me out. So
70?
these students can see the bar at its finest with Mr. Louderback. I've got 3 seconds. Can I finish answering this question?
Yes, go ahead.
So it would be that about $75,000 that we would say was subject to that obvious. And then I won't go into it because I'm over, but we cited the medical proof from the 2 doctors that we felt like justified the necessity of the follow-on treatment that was contained in Exhibit 17. So I'll thank you very much, and I'll sit down now.
Okay, thank you. Here's the appellant rebuttal.
If I may address briefly the cross-appeal issue on the medical bills, there was no testimony about necessity at all. If the theory of a plaintiff is going to be this is open and obvious, then why call a doctor to testify? There's no reason to. That was never argued at trial, and we would suggest that that argument's been waived.
Well, did the doctor testify that it was an open fracture, leg fracture?
He testified it was a bad injury. I can't remember the specifics of what he said. He
Okay.
did testify it was a bad
Okay.
femoral injury. But if you're going to go 40 miles an hour in the back of a sweeper truck without taking evasive measures, that's probably going to happen, knock candor. Here's another issue.
Are you conceding to the fact that it was open and obvious?
I don't know. I can't recall. I don't know. We're not going to concede that, certainly not.
Yeah.
But I do know
But
there was
if
no.
the doctor testified that it was an open fracture of one of the leg bones, I don't remember which.
Femur.
Femur,
Femur,
thank you. The big one. I mean, isn't it obvious that medical treatment is necessary, emergency medical treatment is necessary? I don't know about the rest, but emergency medical treatment.
I will agree that medical treatment was necessary.
All right.
I have no idea what those bills are, and I don't know what's reasonable. When you go to a hospital and get billed $10 for a toothpaste and a toothbrush, I don't think that's reasonable. So the problem with their proof on that issue, they didn't present any bills. The trial court acknowledged this in its opinion. It had nothing to review. There's no evidence in the record other than this itemization. And we did submit a timely notice of rebuttal, and the deposition of the Dr. Witherspoon, the nursing care facility director, she testified she couldn't say what was reasonable or necessary. The problem we get into on this is defending these kind of cases. If you're sitting there in a doctor's deposition and the question's not asked about necessity of a bill, whoa, do I bring that up? They've closed. If I bring it up, it's going to open the door
probably
for
wouldn't.
redirect. I'm sorry?
I probably wouldn't.
I
if I were you.
didn't, and I deliberately didn't, because I'm faced with this dilemma, right? There's no reference to open and obvious pre that deposition. There was no expert disclosure given about that doctor that they wouldn't be utilizing him for open and obvious. And I'm about to run out of time, so if I may jump from that very quickly to the public duty doctrine. Who is this sweeping activity for? Really, that's the question, isn't it? Who is it being performed for? There is no evidence in the record that Mr. Kimbrough knew Mr. Hurst or had any idea it was coming. Zero. And for the last 20 years, Mr. Kimbrough had never swept that street for Mr. Hurst. He had done it for the public in general. That implicates the public duty doctrine. That implicates
Part of the public in general?
Sir?
Isn't he part of the public in general?
He is part of the public in general. Yes, I would agree with that.
How
And
could you make a separation then? How could you say it has to, the duty has to be directed to him without knowing, other than the fact that he is just another citizen using the roadway?
there has to be a link. They have to put on, in response to that question, is that trial, they have to establish that link of a special duty of care owed that individual. Or there's other categories, none of which apply here, class action suits, for example, or doesn't apply here when you get into gross negligent, reckless conduct. None of that applies
Now,
here.
of course, Supreme Court's told us that gross negligence is not waived for the government.
Gross negligence.
Not that you're hung up on that.
It is.
No, not that I'm hung up on that. The Supreme Court
the
reversed
entity
me.
retains
so-
immunity, right, for gross negligence. The employee doesn't. Now, these poor employees are going out there,
yeah.
they don't have immunity
Yeah,
under that.
that was the point the Supreme Court made, that don't worry, you can go collect from the employee.
I'm
But
right there
again,
with you,
but again,
Judge.
it didn't bother me a bit.
I can smell the sarcasm, and I hear you, and I don't disagree with you at all. But what we know now, Judge McCarty, especially to your question, they have to prove that special duty in order to breach the protections of immunity under the special duty doctrine. If, going back to your original question to me earlier, discretionary function immunity doesn't apply. That's the first step. Get to discretionary function immunity. If the GTLA immunities don't apply, let's move on and see, did they plead? No. Did they prove? No. A special duty of care owed. If not, immunity attaches to the entity, just like it did Hawkins County and Lawson versus Hawkins
We
County.
gave you a little extra time because we
You
asked you
did,
so much there.
and
but
I
we're
very
good
much
now.
appreciate that. Thank you, and it's good to see you all.
Court's thanks to counsel for both sides. We appreciate your briefs and your argument on this today.